Who's to talk? Once inside your home or office, just by looking around, they can easily gather information about your lifestyle, organization, and reading habits. The right to be free from unreasonable searches and seizures is based on the Fourth Amendment law, the Constitution. This amendment is supposed to protect against government access lawyer mail and other written communications, telephone and other conversations. Unfortunately, it is difficult to detect government interference with writings and conversations. Modern technology makes it difficult to detect electronic surveillance on a telephone line, other listening devices, or cameras that record whatever occurs in a room. Also common are physical surveillance, such as agents following in car or on foot, mail covers, and informers carrying tape recorders. What should I do if police, FBI, or other agents appear with an arrest or search warrant? Agents who have an arrest or search warrant are the only ones you are legally required to let into your home or office. You should ask to see the warrant before permitting access. And you should immediately ask to call a lawyer. For your own physical safety, you should not resist, even if they do not show you the warrant, or if they refuse to let you call your lawyer. To the extent permitted by the agents conducting a search, you should observe the search carefully, following them and making mental or written notes of what the agents are doing. As soon as possible, write down what happened and discuss it with your lawyer. What should I do if agents come to question me? Even when agents come with a warrant, you are under no legal obligation to tell them anything other than your name and address. It is important, if agents try to question you, not to answer or make any statements, at least not until after you have consulted a lawyer. Announce your desire to consult a lawyer, and make every reasonable effort to contact one as quickly as possible. Your statement that you wish to speak to the FBI only in the presence of a lawyer, even if it accomplishes nothing else, should put an end to the agent's questions. Department of Justice policy requires agents to cease questioning, or refrain from questioning, anyone who informs them that he or she is represented by a lawyer. To reiterate, upon first being contacted by any government investigator, the safest thing to say is, "Excuse me, but I'd like to talk to my lawyer before I say anything to you." Or, "I have nothing to say to you. I will talk to my lawyer and have her, or him, contact you." If agents ask for your lawyer's name, ask for their business card, and say you will have your lawyer contact them. Remember to get the name, agency, and telephone number of any investigator who visits you. If you do not have a lawyer, call Movement Support Network hotline 212-477-5652, or call the local office of the National Lawyers Guild. As soon as possible after your first contact with an investigator, write a short memo about the visit, including the date, time, location, people present, any names mentioned by the investigators, and the reason they gave for their investigation. Also, include descriptions of the agents and their car, if any. This may be useful to your lawyer and to others who may be contacted by the same agents. After discussing the situation with your lawyer, you may want to alert your coworkers, friends, neighbors, or political associates about the visit. The purpose is not to alarm them, but to ensure that they understand their rights. It might be a good idea to do this at a meeting at which the history of investigative abuse is presented. "If I don't cooperate, doesn't it look like I have something to hide?" This is one of the most frequently asked questions. The answer involves the nature of political intelligence investigations and the job of the FBI. Agents will try to make you feel that it will look bad if you don't cooperate with them. Many people not familiar with how the FBI operates worry about being uncooperative. Though agents may say they are only interested in terrorists or protecting the president, they are intent on learning about the habits, opinions, and affiliations of people not suspected of wrongdoing. Such investigations, and the kind of controls they make possible, are completely incompatible with political freedom, and with the political and legal system envisaged by the Constitution. While honesty may be the best policy in dealing with other people, FBI agents and other investigators are employed to ferret out information you would not freely share with strangers. Trying to answer agents' questions, or trying to educate them about your cause, can be very dangerous as trying to outsmart them, or trying to find out their real purpose. By talking to federal investigators you may, unwittingly, lay the basis for your own prosecution, for giving false or inconsistent information to the FBI. It is a federal crime to make a false statement to an FBI agent or other federal investigator. A violation could even be charged on the basis of two inconsistent statements spoken out of fear or forgetfulness. Are there any circumstances under which it is advisable to cooperate with an FBI investigation? Never without a lawyer. There are situations, however, in which an investigation appears to be legitimate, narrowly focused, and not designed to gather political intelligence. Such an investigation might occur if you have been the victim of a crime, or are a witness to civil rights violations being prosecuted by the federal government. Under those circumstances, you should work closely with a lawyer to see that your rights are protected while you provide only necessary information relevant to a specific incident. Lawyers may be able to avoid a witness appearance before a grand jury, or control the circumstances of the appearance so that no one's rights are jeopardized. How can grand juries make people go to jail? After being granted immunity and ordered to testify by a judge, grand jury witnesses who persist in refusing to testify can be held in civil contempt. Such contempt is not a crime, but it results in the witness being jailed for up to 18 months, or the duration of the grand jury, whichever is less. The purpose of the incarceration is to coerce the recalcitrant witness to testify. In most political cases, testifying before a grand jury means giving up basic political principles, and so the intended coercion has no effect. Witnesses continue to refuse to testify. Witnesses who, upon the request of a grand jury, refuse to provide physical exemplars, samples of handwriting, hair, appearance in a lineup, or documents, may also be jailed for civil contempt, without having been granted immunity. The charge of criminal contempt is also available to the government as a weapon against an uncooperative grand jury witnesses. For criminal contempt there is no maximum penalty. The sentence depends entirely on what the judge thinks is appropriate. Charges of criminal contempt are still rare. They have been used, however, against Puerto Rican independentistas, especially those who have already served periods of incarceration for civil contempt. Is there any way to prevent grand jury witnesses from going to jail? There is no surefire way to keep a grand jury witness from going to jail. Combined legal and community support often make a difference, however, in whether a witness goes to jail and, if so, for how long. Early awareness of people's rights to refuse to talk to the FBI may, in fact, prevent you from receiving a grand jury subpoena. If the FBI is only interested in getting information from you, but not in jailing you, you may not receive a grand jury subpoena. What can lawyers do? A lawyer can help to ensure that government investigators only do what they are authorized to do. An attorney can see to it that you do not give up any of your rights. If you are subpoenaed to a grand jury, your lawyer can challenge the subpoena in court, help to raise the political issues that underlie the investigation, and negotiate for time. Your lawyer can also explain to you the grand jury's procedures and the legal consequences of your acts, so that you can rationally decide on your response. Errata. A law enforcement official can only obtain your name and address if he or she has a reasonable suspicion to believe that you have committed or are about to commit a crime. Note number 2. Thus, If an FBI agent knocks at your door, you do not have to identify yourself to him. You can simply say, "I don't want to talk to you," or "You'll have to speak to my lawyer," and then close the door. An FBI agent, unlike a local police officer, does not have jurisdiction to investigate violations of state statute. First edition, published March 1985. Published by Center for Constitutional Rights. 853 Broadway, 14th floor. NY, New York 10003. 212, 674 3303. The Center for Constitutional Rights, CCR, is a non-profit legal and educational corporation dedicated to advancing and protecting the rights guaranteed by the United States Constitution and the Universal Declaration of Human Rights. Contributions to the CCR are tax-deductible. Additional copies of this publication can be ordered from the Center for Constitutional Rights at the address above. Here. Comments about this publication will be appreciated and will be useful in preparing future editions. This pamphlet was prepared by the Movement Support Network with the help of Linda Bacchiel, Joan Gibbs, Jonathan Ned Katz, Margaret L. Ratner, Audrey Seniors, and Dorothy M. Zellner. Photographs, Maddie Miller. Notes. 1. 1C Final Report of the Senate Select Committee to Study Governmental Operations, 94th Congress, 2D. Session, Report Number 94-755. 2. 2C For example, United States v. Hensley, 83 liters. Ed. 2D 604, 1985, Collender v. Lawson, 461 U.S. 352, 1983, Brown v. Texas, 443 U.S. 47, 1979.